To the next case, which is CRONIN v. State.
Good morning, judges, counsel. May it please the court, I'm Nancy Ryan, representing the appellant Joe Cronin. This is another Judge Howard case, and it's a fairly straightforward case. Our position is that trial counsel who tried the case back in 2002 was ineffective for his failure to object to a jury instruction that allowed the jury.
Ms. Ryan, let me ask you some questions about the jury instruction. There's a decision from our court that indicates that it may have been erroneous, and so there was a prior appeal of the conviction where the erroneous jury instruction was raised, and apparently the instruction wasn't objected to, and the state argued that it wasn't fundamental error because it didn't go to a disputed element in the trial. And so this court apparently accepted that argument and affirmed. Is that basically correct?
Yes, Judge. Okay.
Then we have testimony from Mr. Cummins during the hearing that for purposes of what was actually tried, it wasn't a complicated case, and the only defense was going to be that this person, it was consensual. That this person, although may have been mentally defective, that the person, in essence, consented to the sex act, and that. And then he says, and I quote, I mean, that's the whole crux of the entire case, and that they weren't going to contest the fact that the sex acts had actually been committed. And so what we have now is basically a ruling by this court that in the prior appeal that wasn't a contested issue. And then we have Mr. Cummins testifying that the only defense they were going to present was that it was consensual, and they weren't going to contest the fact that the act had been committed. And then Mr. Cummins also testified that he discussed this trial strategy with his client, the defendant in this case, and he agreed. So my question to you is, given all that, how do you satisfy the prejudice prong of Strickland?
The strategy was to agree that the acts confessed to had taken place. Mr. Cronin didn't agree on the audio tape that he had, in fact, committed every act she alleged, or she made wide-ranging allegations.
Okay, let me quote to you then from Mr. Cummings during the trial. Ladies and gentlemen, this case isn't going to be about whether a sex act occurred between my client and this 21-year-old girl. This case is going to be about whether my client either forced this girl to have sex with him or whether this girl was capable of consenting to have sex with my client. That's what this case is going to be about. And then he testified in the hearing that's what the case was about. He told the jury that's what the case was going to be about. And then in the hearing on this post-conviction relief motion, he told the judge that's what the case was about, that's what their strategy was, and that the defendant agreed to it.
But he also told the judge at the ineffectiveness hearing that he wasn't, to that day, he wasn't clear on what Mr. Cronin was convicted of and what exactly he was acquitted of. That's at Volume 2, pages 198 through 99. So I'd submit that you've got ineffective assistance in failure to raise this obvious error in the jury instructions.
Okay, but I understand that. But my problem is, how is it prejudicial? I mean, you have to meet that prong of Strickland. And we have trial counsel who was apparently effective, at least somewhat, because, I mean, this guy was charged with other offenses and he was acquitted. And when you look at the actual outcome, it's kind of hard to imagine that Mr. Cummins and his associate were not effective during the trial. So what we have here is a trial strategy which apparently worked to some extent, saying we're not going to contest that the sex acts occurred, we're going to say it was consensual. And then he tells the jury that that's what the case is all about. And so then we have an erroneous jury instruction. And my question to you is, if that was the strategy, and that's the defense that they put before the jury, and that's what they told the jury, how is it prejudicial, even if we say that the jury instruction was erroneous?
It's prejudicial in that the case should have been about more than one issue. It should have been about a challenge to this jury instruction. It should have been about the alleged victim's veracity.
Well, then are you talking now about whether the trial strategy was wrong, or whether he was ineffective for failing to object to a jury instruction when, number one, it wasn't a contested element in the trial, number two, their whole strategy was, we agree the sex act occurred, it was consensual.
Their strategy was that they agreed the acts he confessed to on the tape took place.
Well, where does that's not what he testified to. He testified to our entire strategy is it was consensual.
Well, if you read the trial, the counsel takes the victim's testimony apart. There was a secondary defense at the trial, although it's not mentioned at the 3850, but the secondary defense in closing at the trial was that the victim was unreliable because she had alleged such different things at different times. And in view of that, I think you've got ineffectiveness, not only in the failure to object to the jury instruction, but in the failure to investigate the victim's reputation for truth and veracity. The counsel said at the 3850 hearing he didn't bother to go into that in her neighborhood or at her special school because that wasn't the issue in the case. But of course it was an issue in the case. When her allegations were so all over the place that at one point she's got Mr. Cronin chasing her around the trailer park with a mask and a gun. And the rest of the time she doesn't mention anything like that at all.
Maybe the victim then, her testimony to a certain extent, maybe it was incredible. Maybe the jury took that into consideration when they acquitted him of some of these charges. But the specific issue I'm concerned about is the erroneous jury instruction being a prejudicial and meeting the prejudice prong of Strickland, based on what I just presented to you in terms of what the trial strategy was, and the fact that the trial strategy was agreed to by your client, and the fact that this court had found in the prior appeal that wasn't even a contested element in the case. I mean, I'm really concerned about that.
It wasn't a contested element, but it should have been. The jury instruction allowed the jury to inadvertently reach a guilty of a felony when they only found facts that made him guilty of a misdemeanor. The jury instruction mixed elements of a felony and a misdemeanor.
Or should that have been a contested element of the trial when the trial strategy was that we're saying the sex act occurred, we're just saying it was consensual?
It should have been contested at the charge conference or at the time the jury was instructed. It wasn't part of the strategy with the jury, but it most certainly should have been raised with the court at some point. And that's our position, that it combined elements of two offenses in that the instruction allowed them to find a verdict of guilty if they found digital penetration of or union with the girl's anus.
Was there any testimony as to that actually occurred?
She testified that it did. He did not. And I apologize to the court for making you do my job for me and supplement with the tape. I should have supplemented with the tape. I should have seen that the trial transcript that we got this time around.
My question to you is, was there any testimony presented during the trial that this little girl was anally penetrated?
She said she was.
With the finger?
No. She said he put that little piece in my butt, and she identified the little piece, you can tell from the context, as his penis on the anatomical doll.
Okay, and wasn't there some testimony that he put a needle in or something like that? I mean, the point that I'm getting at is that there was testimony that this girl was anally penetrated, either by what she referred to as a needle or by the man's penis, and so there was evidence to that effect before the jury, wasn't there?
There was evidence to there was her evidence, but her evidence was, I would submit, totally unreliable, and that's reflected in the verdict.
Okay, no, hold on now. We're talking about an erroneous jury instruction, and I've already explained to you my concerns about that. Now we find out that there's actually testimony that was presented to the jury that what the state accused this man of doing actually happened by her testimony, by Dr. Petter or somebody else, but that evidence was presented to the jury. And so, that makes me even more concerned that given all of that, his failure to object to the erroneous jury instruction was not prejudicial.
I submit that effective counsel could not ignore this aspect of the jury instructions, regardless of the strategy he took with the jury. I submit that there's just got to be prejudice, and since her testimony was so variable, who knows what they made of the needle testimony?
Don't you have to essentially show in prejudice that the outcome would have been different?
Sure.
Had the jury instruction done. Explain to me how the outcome would have been different given the trial strategy, the fact that it wasn't a contested element, at least we found it wasn't in the prior trial, and there's evidence presented to the jury that what they accused this man of doing, he actually did.
Well, the jury was in an acquitting mood, evidently, and they found him guilty of only the simple battery on the vaginal allegation, even though the defendant admitted on the tape that he had inadvertently penetrated her vaginal area. I submit if they'd had the opportunity to find that a simple, well, they did have the opportunity to find a simple battery, but the jury instruction allowed them to find either the simple battery or the sexual battery on the anal count. And
well, if the jury was in an acquitting mood, maybe it was because of the trial strategy and because of Mr. Cummings' effective assistance of counsel. I mean, he came out with a fairly good result here, given the what they had charged him with in the acquittals. I mean, I don't know that this is a bad result for your client. I mean, and I would think that we have to attribute some of that to effective assistance of counsel by Mr. Cummings.
I submit you should attribute it to the victim's testimony being so internally inconsistent. But the verdict's a head-scratcher because if they had only found Mr. Cronin guilty on count 2, that could easily be attributed to his admission on the confession tape. But he didn't admit anything to do with anal intercourse. So where did
that gap was filled in by the testimony from the little girl. I don't know if Dr. Petter testified at trial. I know he testified at the hearing as to whether the little girl was going to be able to testify or not. And the little girl's testimony somehow was presented to the jury by other witnesses, and that included the fact that this man anally penetrated this little girl, just as they had alleged.
That's true.
I'm really, you haven't helped me much with the prejudice problem of Strickland, actually.
I just submit, how can it not be prejudicial to ignore a jury instruction that allows a verdict on one of two cases, on one of two sets of facts? How could that be less than prejudicial when they might have reached a different verdict had they had proper jury instructions? I submit it's, well, I'm relying on the cases cited in the brief, Gary and Yarbrough, where they found it prima facie ineffective to not object to an instruction that contained elements of two different offenses going off in different directions. I submit that those cases control. That's Gary from the second DCA and Yarbrough from the first DCA. I submit that whatever happened with the juror in the presence of the jury just doesn't affect the prejudice of what didn't happen with the court in the charge conference. I'll reserve my remaining time, if I may. Yeah. Okay.
May it please the court. My name is Douglas Squire, and I represent the appellee, the state. To back up a little bit with Judge Sawaya's first question, below at the evidentiary hearing, defense counsel specifically testified on page 189 that based on the defendant's previous statements, they decided not to contest the state's theory of the case, not just anything he specifically admitted to. And when you listen to the tape, things that were inaudible in the transcript provided in the record became audible, so that there is no specific admission by him to digital penetration. The tape itself shows that he had denied everything until he was reminded of these previous statements. Then he started admitting what was specifically asked of him by the officer. He was never specifically asked about digital penetration. But the jury's verdict shows that they believed both of them. He was acquitted of 1, 4, and 5. The counts that he was convicted of were consistent with her testimony that they were forced. This did come down to an issue of consent. She was consistent throughout the trial testimony with the teacher, Sue Jordan, that Joe had hurt her butt. When the first deputy interviewed her, she said Joe touched her butt. He forced her to lay on his bed. He would not let her up. On the videotape, she said he touched her butt with his hand. He put stuff on it, presumably some sort of lubricant. And this was after he pushed me down. He slammed me down there in his bedroom. He touched her down deep with his hand. She was sore. And Dr. Petter testified that she referenced the second occasion. I believe there was an unvideotaped interview with the victim. And that was where the victim used the word little piece and needle. She never actually said finger, but we don't know what she meant by needle. And the doctor explained that victims with Down syndrome think that being more helpful if they start grabbing descriptive terms and adding it in. As far as attack of the victim's credibility and truthfulness, as she stated, this wasn't in the 3850. The lack of preparedness was. But they were given the opportunity at the evidentiary hearing, and they never came up with these witnesses that supposedly said she had a reputation for sexual aggressiveness at the school. And then if you actually read the testimony, I believe it's on page 174, counsel explained that this was actually reported by Mr. Cummins, no one else. So this is a self-report that she allegedly has this reputation at the school. And then when he was given the opportunity to bring this out, he brought nothing. So it would have been sheer speculation. We're on 3850, not direct appeal. I think you've covered most of it's already been found not to be fundamental error on direct appeal. So if there are no further questions, I would rely on the state's brief. I ask you to affirm.
Okay.
Judges, as Mr. Squire just pointed out, some of her testimony was that he touched my butt. The jury may have believed that, but not have believed the penetration testimony. She did testify that she had been penetrated vaginally, and the state's own expert proved that that could not have happened. She was a virgin. So if the jury believed that she had been merely digitally handled, they still could have reached a verdict of guilty on the felony based on the erroneous jury instruction, and I submit that that cannot be non-prejudicial. That's our position. Anything else bothering the court that I should address? Thank you.
Thanks. We're going to take a break, and we invite counsel here if you'd like to join us for coffee next door.